I'm Josh Escovedo with Weintraub Tobin.
And I'm Scott Hervey with Weintraub Tobin. A company founded by Jack Nicklaus, Nicklaus Companies LLC, has been awarded a preliminary injunction which enjoins Jack Nicklaus from using his name, image, and likeness in commercial endorsement deals. The judge who entered the ruling called it awkward, but it's an interesting look at the interplay between non-compete clauses and the transfer of intellectual property rights. We're going to discuss this case on this 100th installment of the briefing by the IP Law Blog. In 2007, Jack Nicklaus and GBI Investors, a company owned and controlled by Jack Nicklaus, entered into an agreement with Nicklaus Companies LLC, a company formed by real estate magnate Howard Milstein, whereby for $145 million, Nicklaus Companies purchased certain assets of GBI, which included a substantial portfolio of trademark registrations and applications related to Mr. Nicklaus's name, signature, and the Golden Bear nickname in the United States and in various other countries throughout the world. Totaling more than 600 trademark registration and applications in the U.S. and 50 other countries. Also included in the purchase was the exclusive right to the golf course design services that were rendered by GBI and the marketing, promotional, and branding business of GBI, which included the right to use Nicklaus's name, image, and likeness. The complaint alleges that Nicklaus Companies became the sole owner of these rights and the right to use all of the intellectual property related to Jack Nicklaus. GBI and Mr. Nicklaus became members of the company, and Mr. Nicklaus became one of its managers.
In 2017, Jack Nicklaus retired from his day-to-day involvement with Nicklaus Companies, but according to the complaint, he still provided services on Nicklaus Companies or its subsidiaries when required. However, the complaint alleges that after Jack Nicklaus retired, he repeatedly participated in deals for use of his name, likeness, and trademarks, including personal endorsements outside of the Nicklaus Companies, which included Jack Nicklaus being paid to promote a European Tour golf tournament, which included the tournament's right to use certain Nicklaus IP. The complaint also alleges that Jack Nicklaus attempted to steer a Nicklaus company opportunity for a marketing and endorsement relationship to a one-off personal appearance deal for his own personal benefit to the detriment of the companies. The complaint also alleges that Nicklaus is directly competing with the Nicklaus companies for golf course design projects, and he is personally negotiating to renew his endorsement deal with Rolex.
In the plaintiff's motion for a temporary restraining order, the plaintiff argues that the 2007 transaction resulted in the purchase of all golf course design services branded and identified under Nicklaus, Jack Nicklaus, and the Nicklaus signature brands. The various marketing, promotional, and branding activities involving the use and licensing of Jack Nicklaus's persona, personal endorsements, and other commercial rights to publicity and intellectual property related to the Jack Nicklaus identity, his history as a recognizable public figure, and the Golden Bear brands. The transaction documents included a purchase agreement whereby GBI transferred the assets, the rights, and the business interests to Nicklaus Companies. Also, a non-compete agreement that Jack Nicklaus signed personally, which restricted Mr. Nicklaus from competing with the plaintiff, including a competition by providing his personal services as a spokesman or authorizing the personal use of his name or likeness for the business, products, or services in competition with Nicklaus Companies for as long as GBI retained an ownership interest in the company sufficient to elect at least 2 members of the board of managers, but in no event for a period of less than 10 years after the date of closing.
In opposition to the TRO, Jack Nicklaus argued that he's free to conduct his own business because the non-compete agreement that he signed in connection with the 2007 transaction expired in 2017 when he left Nicklaus Companies, and most certainly when GBI transferred all of its interest in the Nicklaus Company back to the Nicklaus Company in August 2022, which transfer the company contends is not valid. Nicklaus argued that it was GBI that sold assets and businesses to the plaintiffs, not him personally, and that he was only bound by the non-compete.
The crux of Jack Nicklaus's argument was laid out by his counsel in the oral arguments on the TRO motion, that Jack Nicklaus personally never transferred any rights to the Nicklaus companies personally, and that GBI transferred whatever rights it had to the Nicklaus companies. And there was no transfer of Mr. Nicklaus's name, image, or likeness to GBI before GBI made the transfer to the Nicklaus companies. His attorney argued that the Nicklaus companies assumed that this initial transfer of rights between Jack Nicklaus, the individual, and GBI had occurred before GBI sold all of those rights to the Nicklaus companies. But Jack Nicklaus's attorney said it didn't happen, and there's no documentary evidence that it did.
So essentially, Jack Nicklaus's attorney was arguing that despite the transfer of all of the trademark rights and the rights to golf course design and endorsement and sponsorship business in the name of Jack Nicklaus, because Jack Nicklaus never transferred his name and likeness to GBI, once the non-compete expires, he can use the name Jack Nicklaus to compete with the Nicklaus companies in those business sectors.
That's right. But it seems that those arguments did not resonate with the court. After a 3-day hearing, the New York Supreme Court Justice Joel Cohen entered a preliminary injunction prohibiting Jack Nicklaus from using his name and likeness from competing with the Nicklaus companies. Although Jack Nicklaus can compete with the Nicklaus companies for golf course design jobs, he can't use his name and likeness in doing so. While the non-compete has expired, the ownership of the Jack Nicklaus intellectual property resides with the Nicklaus companies, and that isn't something that expires, Justice Cohen said. The exploitive value of Jack Nicklaus's name as an endorser of products and the like is where the line is drawn, said the judge.
The holding makes sense. When a public figure registers their name or nickname as a trademark, such as The Rock, and then transfers those trademark rights, any right of publicity that one may have in that name or nickname is subject to the trademark rights held by that third party.
I agree, Josh. And by the way, the trademark The Rock is owned by WWE, World Wrestling Entertainment, which kind of explains why Dwayne Johnson does not really personally present himself as The Rock anymore. So this raises the question about how public figures should go about protecting their brand, especially when that brand becomes the brand of a business. It's easy to address when that business is controlled by the celebrity, but when it's no longer controlled by the celebrity, or when the business takes out loans that are secured by business assets, which generally always includes company trademarks, as seen in this case, it can become complicated and convoluted very quickly.
That's right, Scott. That really does underscore why public figures need to seek competent counsel on these issues. This was very interesting. Thank you for sharing.
Thanks, Josh.
Thanks for tuning into this 100th installment of the briefing by the IP Law Blog.
If you're a new subscriber, well, you've got 99 other episodes to either listen to or watch.
And that means 99 to 100 reviews that you can leave as well. Make sure they're positive, though.
And if you're interested in more content like this after listening to or watching our 99 other programs, please visit us at theiplawblog.com.